The Honourable David Parker.
Thank you, Mr Chairman. Can I begin by thanking the officials? We see a range of officials and they're generally very good at Select Committee, but it's refreshing when we see officials that are so over their understanding of complex issues that they're able to engage with the Select Committee and not just hold a line in defence of what is proposed, but engage in discussions which both educate the committee but also show some movement on the part of officials at times when perhaps the policy intent's clear, but that there are details that need to be addressed. And we found the officials, or I found the officials on this advising this Select Committee and providing advice to be of the highest calibre, so thank you. There are a couple of issues that I want to address in this contribution, Mr Chairman. The first relates to why it was necessary to change provisions relating to government workforce policy orders. And that's the language that was used in the form of the bill that came to Select Committee. Clause 42 of the bill, or Part 5 of the the new Part 5 of the Act, as inserted by Clause 42 of the bill to amend and insert a new Section 55A into the Act, more precisely, provides for government workforce policy statements. And these workforce policy statements are very broad in their ambit, and they were described as orders, and the orders could be the Governor-General could, by order in Council on the recommendation of the Minister, approve a government workforce policy as a government workforce policy order, as if it was something akin to a government regulation of some kind, but then they went on to say that those orders were not a regulation for the purposes of the Regulations Disallowance Act, or the Acts and Regulations Publication Act 1989, and Labor members of the committee were concerned that the ambit of these regulations was so wide as to allow the government to effectively issue a directive which was akin to a order by the executive, which would have enormous power across the whole of the state services. But they didn't need to come to Parliament in respect of it, and there was no ability for people to challenge it under some of the regulations, under the Regulations Disallowance Act 1989. And that was wrong, and on the Labor Party's side we were aware that, of course, the government that's been the most egregious in its use of statutory regulations in the past was another national government under Mr Muldoon, who gave himself hugely broad regulation-making powers under the Economic Stabilisation Act, which allowed him, by government regulation, to impose a wage freeze. And he did. Incredible though it now seems, he did that by way of statutory regulation. And we, on the Labor Party side, thought that the subsequent Longy government, with Geoffrey Palmer's assistance in this regard, cleaned up a lot of that silly, overly broad regulation-making power and tried to make it sure that the big decisions for New Zealand were taken by Parliament, not by ministers using executive powers. And so we were concerned at this proposed provision allowing government workforce policy orders to be made was so broad as to allow the government to effectively say there will be a wage freeze across the public sector. And we asked officials whether that was the case, and they said that wasn't the intention, but it did appear to be that was the effect of the words, or at least that was a concern that I had. The Select Committee agreed that across both party sides that was inappropriate, that the power of the executive, the power of the government to make workforce policy orders should not be that broad, because indeed it would be absurd to be giving the executive powers that broad. And so the Select Committee has recommended to the House that we amend the provisions in respect of government workforce policy orders that we start to call them, Mr. Chairman,
David Parker.
that we call them instead government workforce policy statements rather than orders. So already you can see that they're not sounding as legislation-like as the original language proposed. They still are a statement, they still can't be, they're still not a regulation for the purposes of the Regulations Disallowance Act, but there is a statement at the new section proposed 55D, which says that notwithstanding that a department must give effect to a government workplace policy statement, the policy statement cannot create, alter or remove employment or other legal rights or obligations. So if there is an existing employment right, well, that can't be taken away by a workplace order. If there are existing legal rights or obligations on the employer, for example, to embark upon good faith bargaining, then this provision could not be used to cut across those obligations and impose a wage freeze. So the Labor Party is pleased that that was picked up by submitters and that this change has been made. Mr. Chairman, I want to raise another issue which I've spoken of previously and which is raised in our minority report. The Labor Party is still not convinced that it's right in principle that the public service are immune from liability as opposed to be indemnified for the consequences of their actions. The Labor Party, we do not believe that public servants who are acting in good faith, no matter how negligent they are, they should be protected from the consequences of civil liability for their actions. But that doesn't mean to say, in our view, that they should be immune from prosecution. Immune from suit is a better way to put it. Or immune from prosecution of the suit, if I was trying to cover my own language there, which is rather loose. Mr. Chairman, we had submissions from the Legislation Advisory Committee who said that it's wrong in principle that the public service are immune from liability in civil proceedings. They thought they should be indemnified in their duties rather than have an immunity from prosecution. There are a couple of reasons behind that. One, they say that do we really want to live in a society that a public servant who acts egregiously cannot be brought before a court and suffer the embarrassment in a civil proceeding of being involved in the proceeding. The State Service, the Legislative Advisory Committee, or was it the Law Commission? I forget which. I might have that the wrong way around. One of those two august bodies, the Law Commission, thank you, David Cunliffe, it was the Law Commission, came to us and said that what we risk doing is actually creating a faceless bureaucracy and that there should be some accountability for conduct. So if conduct is egregious, why in the public sector wouldn't you be required to appear in court in a civil proceeding as a party and suffer the consequences of that process as opposed to the consequence of the award of damages that might flow from at the end? And why isn't indemnity enough? And if you look at the comparison, and I know the comparison isn't perfect, but there is some truth in the comparison that if someone was in the private sector and you were acting in the course of your employment for a private employer and you made a mistake, then you could be sued in your own name, probably, in some situations, and you certainly wouldn't have immunity from prosecution. You would at most have a right of indemnity, and in the case of the injured party in society who has had harm caused to them by an arm of the state through this public servant doing something wrong, and it could be deliberately wrong even if it wasn't maliciously wrong. Why is it that there is some question as to whether the private citizen who suffers that injury has got a right of action against the individual? Now, one of my concerns in this, and it was something that we explored with the Law Commission, is that there is a difference between the rights of the Crown, the liabilities of the Crown who are vicariously liable for the actions of their employees is sometimes not as broad as the as one might think. And I can see I'm running out of time here, Mr. Chairman. I'm not, Mr. Chairman.
Call Denise Roach.
Mr. Chairman, I want to start my contribution